Good morning, Jim Sansone appearing for the Guardian, Joy Thomas.
Aaron Winkle's appearing on behalf of the mother, Carol Lavender. I don't see Tina Day, though, the GAL.
The order originally appointing her has expired. And I think the first order of business will be reappointing Ms. Day.
Okay.
Ms. Day, are you in the hearing by chance? Doesn't look like it.
And I know she just went out to visit my client on site where my client lives. And I know she said she did need more time, that she was not going to have a report today.
Okay. So council, if you'd submit an order reappointing Ms. Day.
Will do.
All right.
And then should we set it over 2 more weeks or 3 weeks to give her time to finish that?
What's the visitation schedule right now?
I believe mom has, and my client's here, I believe mom has 2 nights a week. Dad has 2 nights. Is that correct? Give me a thumbs up. Carol. 1 night.
Okay.
Okay.
All right. If this works for everybody, let's go out 3 weeks.
That works for me.
That works for us, Your Honor.
All right. And keep everything else as is.
All right. Sounds good. Thank you, Your Honor.
Thank you.
Good morning, Your Honor. Jennifer Joslin, for Miss Johnston, mother. And we were going to be asking for a set over, Your Honor. I don't know if you want to address that first. Oh, wait, I don't know if the guardian's here.
We have Ms. Gill.
And I do see Miss Gill here, Your Honor. She chatted that she's not able to turn her video on.
All right. Can you hear me, Ms. Gill?
Now I don't see her anymore.
Do we have Ms. Gill? All right, counsel, if you don't mind, let's come back to this one, see if she comes back on.
Hockey here representing father, Jeremy Layton.
Sherry Farr, the court visitor.
Gina Canoni, guardian.
And just so everyone's aware, it has been quite some time, but I knew Ms. Bornstedt in her youth. I don't see any reason not to proceed on this case today, but I just want everybody aware of that. All right, counsel, where do we stand?
I believe it was my understanding that the report from the DCYF or CPS, we're waiting for that report in order for final entries to be entered. Somebody can correct me if I'm mistaken on that.
Your Honor, we were waiting for that. The CPS records have come in now. Ms. Canoni has sent me her proposed findings. I just haven't had time to go through them. So I was wondering if we could set this to 3/27 for entry.
Do we have the full guardianship petition filed, or are we
Yes.
just in the emergency? Okay.
Yes, everything's ready to go. We have the consents. We have everybody's been served by the CPS records now.
So any objection to the will be the 28th then at 10:30?
The 28th, yes.
No objection from us, Your Honor.
All right, March 28th, 10:30.
Thank you.
Thank you.
And I see
Thank you.
Ms. Gill, so let's go back to the Johnston matter.
Sorry about that. I had to rejoin. I have to leave it and rejoin.
No problem.
So, Your Honor, we were going to request a set over. I was just appointed. The case is quite voluminous, so I haven't had a chance to go over it. Additionally, in reviewing the orders, my client's at the point where she can now petition the court to transition the child home. And so that is a motion that we need to file. So my thought was set it over to give her time to do that, so then we can come back to court and start discussing a plan to transition home.
Let me ask the question, Ms. Gill, from your standpoint, how are the visits going?
Not well since November. And in my understanding, she's not allowed to petition the court until we are in phase 4 or doing phase 4. But things were going really well up until November. Her and I were working together. I even petitioned to get her overnight visits months before she would have originally been allowed. When November hit, Gage was introduced to the third man since December 2022 as a new boyfriend. She then started taking him to overnight visits at the boyfriend's house out of town, where she will not disclose the address to me or allow me to pick him up from.
And Your
claimed-
Honor, we're gonna object.
I'm
That's
talking-
not true.
I'm-
She has the address.
All right, everybody hang on. Ms. Gill, go ahead and finish.
All right. So only up until I was given paperwork from the Superior Court did I know the address. It was accidentally put on a piece of paper. She still has not allowed me to pick him up or know where this address is out of town. But for months, she had been still claiming to me she was living at the Oxford house and doing overnight visits there and having me pick him up from a house she was not actually living at or staying at with Gage. The issues I have with him, where she's residing, one, not knowing where. Two, it's with a boyfriend that has just been released from prison within the last few months. And there's 2 other men living in this house, Gage has told me, that I do not know. A man named Tuff and his dad. There is no bedroom for Gage. He's been sleeping in her bedroom, which I don't think is right, especially if she's wanting to have more overnight visits with him. And Gage has been coming home more aggressive because he's been being taught how to box. The aggression at school has increased, and behaviors, to the point where the teachers have called me multiple times to ask if something else has changed outside of our home to cause the increase of aggression and behaviors. And not just with that, but he's coming home and saying that he's not allowed to call me his parent anymore, which he's called me his parent since of age 4, that he is only allowed to call me his aunt because this is all my fault that he's not with his mom, and that he's not my kid, he's her kid. And these types of things should not be discussed to a child at this age, nor a child that is already struggling with regulating his emotions at that regard. So we have had such a low level of communication because of all this and all these, secrets, whereas before she was so transparent about everything.
Your Honor.
Hang on. All right, Ms. Jocelyn?
Yes. So this is one of the things I haven't been able to get into this. And unfortunately, what Ms. Gill is saying is just simply convenient at us wanting to reach out and move to phase 4. I called Ms. Gill 3 times, no response. I emailed her. She finally emailed me back on Monday. This is the first time that myself or my client has heard of this. It's just convenient that after we're talking about restructuring phase 4, that all of a sudden she's freaking out and saying all these things are happening. My client and her had a discussion about potentially changing phase 4, which is why I reached out to Ms. Gill. And then after the 3rd time of reaching out, when she finally responded, and I have emails, we can send it to the court, she's like, no, that's not the agreement. So this is part of the reason why we need to have a set over. I need to get a clear understanding of what's going on. Nothing, Ms. Gill has filed no declaration stating any of this. My client has no chance to respond. She's made no complaints. She's made no motions before the court to change anything. It's time we move into phase 4. My client's going to petition to have the child transitioned. And I understand my client is very thankful for Ms. Gill. And we understand that my client and Ms. Gill have been together for a long time. And unfortunately, part of this is Ms. Gill is upset and having the child is transitioning back. My client has no desire to cut Ms. Gill out. And once he transitions back, still wants her to have time, whether it's every other weekend or a weekend. So my client, unfortunately, with having me just retained, having no information before the court, she can't properly defend herself when nothing that's been said is in any documents. So that's why we're requesting a set over And then we were going to also file a motion to modify phase 4 because that's not, from our position, not the most appropriate thing for phase 4. So I think a set over of a month would be appropriate to give us time to do that. And then if Ms. Gill has anything she wants to file, she can file it in the appropriate time frame. So my client gets a chance to address it and not have it sprung on her.
Okay, here's what we're gonna do. I will put the matter to April the 4th. At 10:30, I'll put at the end of the calendar because there may be a necessity for some testimony. In the meantime, Ms. Johnson, the visits take place at your home, period, end of conversation. Ms. Gill always knows exactly where that child is at any time. Is that understood?
Yes, Your Honor, I live with my significant other, and I told her.
Okay, Ms. Gill or Ms. Johnson, hang on. Whoever else is in that house, you need to make sure Ms. Joslin has all that information. You need to make sure Ms. Gill has that information.
Absolutely.
What's going on with UAs since you're not in the Oxford house?
I just did a hair follicle. Unfortunately, I had it done and I had it sent to all parties. I did forget to file the copy with the courts. I did file it this morning. I apologize for that. I've been gathering all this information, trying to get it with my attorney. So I'm a CDL driver. So between my work schedule and getting everything from my attorney, I did forget to do that, but I did it this morning. I've been clean for 29 months. I've got a career now. I'm doing everything. My son is thriving under my care. Like,
Hey, ma'am, hang on.
It's, Your Honor, to make it easier, she filed, Ms. Gill and I got a copy of the hair directly from Omega Laboratories. She took a hair follicle on 2/22. That was filed today, Your Honor. It is negative for amphetamines, meth, coke, opiates, phenylcyclidine, and THC. My client also has a multitude of UAs that I'm in the process of gathering. I wanted to file it all at once under seal so the court had the total so we didn't have to go back. But for example, one UA I'm looking at right now from 1/18 of this year, again, negative for everything that was screened for.
Okay.
And so,
Your Honor, I have a question about the drug tests also. So in our original parenting plan, it states that I can request any type of drug test and I have to pay for it ahead of time, right? And that if she's negative, she has to reimburse me, which she never has. And if it's negative, I pay it, excuse me. If it's positive, she has to reimburse me. But in September, when we went to court, she asked for it to be changed. And
Okay,
for
so what's
her,
your question?
so my question is back in September, if it was modified, because she asked for it to be modified, that she'd be willing to pay for any tests I request, because I don't ever really request them. And the judge in September said that they don't normally do that, but because we were working so well together and he didn't think I'd take advantage of it, that he would put that in the order that she would pay if I requested it. Well, I requested a hair follicle on the 2nd of February, and she refused unless I paid for it,
Okay,
stating
hang
she
on,
never
hang on.
said that.
Hey, everybody hang on. Okay, the order says respondent shall UA hair follicle upon request at her expense and must provide a follicle test before review for phase 4 in 6 months. So that's still the order. And if somebody owes somebody, that needs to be taken care of.
Your Honor, I think what she's asking is, that was a one-time, that was not saying moving forward. So my client did pay for the hair follicle and that's what she filed today.
All right, well, this one doesn't say one time only. It just says
Yeah.
upon request.
The judge said,
Okay, I'm getting tired of getting interrupted.
I'm sorry.
The secret.
It says upon request. If there has been just one request in 6 months, it's not being taken advantage of. And from Ms. Johnston's standpoint, a current one would probably be a brilliant idea for that hearing in a month. Pending that hearing in a month, Ms. Gill knows exactly where the child is staying at all times. She knows who's in that house. She's entitled to go visit the house if she wants. She's not going to be a regular guest there, but she's entitled to know exactly what's going on. I'm not going to have anybody hiding anything. Everybody understand that?
Yes, Your Honor.
Your Honor.
All right, so April the 4th, and it would also be a good idea from both sides' standpoint to provide some sort of pleadings and affidavit showing where things stand now. So whoever's hearing this has an idea what the issues may be.
May I make a request, Your Honor?
Yes, ma'am.
Yeah, I was wondering if we could do pickups and drop-offs at the local DSHS office, the CPS office. That way there's less conflict. There's been
If you guys can't get along for the pickup and drop off, I want to know about that. Everybody gets to behave like an adult, and anybody who can't, that tells me an awful lot.
that's been part of our issue recently is she
Okay.
keeps attacking me during pickups and drop-offs.
Did you hear what I just said? If anybody can't behave like an adult, that's important information for whoever's hearing this.
Okay.
All right, the
Oh.
4th at 10:30.
Perfect. And I'll work with the parties about pickup and drop off, Your Honor, and try to smooth anything out.
All right. Thank you, counsel.
Thank you.
Thank you.
See Ms. Gill
Your
is
Honor.
present. Good morning. Ms. Jocelyn is present.
And Mrs.
Okay.
Johnston is present as well on Zoom. She has the red box with the C.
Got it. Okay, thank you. And we do not have a visitor on this case. Do we need one on this one?
No,
I
I
think
don't
so.
believe so.
Okay, so where are we at on this one, Ms. Jocelyn?
So we were supposed to move to phase 4 in March. My client had a phase 4-phase visitation schedule, which once she got into phase 4, she could then petition for the child to come home. I got appointed in February, and when we came to our hearing, I believe it was March 7th, Your Honor, we'd indicated that we wanted to amend the phase 4 schedule. And so it has been put over. We filed our motion to amend the phase 4 schedule. So that is what's before the court. Also, phase 4 hasn't started. So we're here today on our motion to amend the phase 4 schedule. I know that the guardian had also filed a motion, but she hasn't cited it on.
Let me see here just a second.
Yes. And for ease, our pleadings were filed March 14th.
All right, and I did receive those, Ms. Gill. Looks like those were filed and we received a copy, at least here, April 10th. That doesn't have a hearing set. Let me see here.
I didn't know I had to set a hearing. I just guess I was thinking I had to submit something as my side of it. So that's on me that there is no court date for it.
And I had tried to ask Miss Gill what she was trying to do. Is this a response or a motion? And she wasn't very clear. So certainly she has her right for the motion, but she would need to cite it, give us notice.
I guess my concern on this case is when I look back through this, this looks like something that this started back in October of 2022. And it was there ever a guardian ad litem in this case?
Yes.
Yes,
this
and then they were
actually-
dismissed.
The guardian ad litem was dismissed when I got final order for guardianship.
Okay.
The original case started back in 2018, and then when the laws changed, they told me in order to be seen in front of the judges again, I would have to file a minor guardianship because we could no longer file into the other case. So it's an extensive,
Right.
It's gone on for a long time.
Right. Yeah, this is one of those that got caught in the middle.
Yeah.
All right. So I guess my question, and again, this is one of those, I was just trying to make sense of it because it was a bit of a kind of a convoluted history because of that.
Yeah.
There were a couple of different orders.
So for the The final orders, Your Honor, in terms of the final residential schedule, while they were made, I believe in 2019, if you look into this matter, they were filed under cover under December 12th, 2022. So they were filed into this case, but there were actually orders that were made earlier. They were just made in the third party case. And so that order that was filed December 12th, 22 outlines the 4 phases.
Okay, and we're currently in phase 3, as I understand it.
Yes, we were supposed to
Yes.
move to phase 4 in March, which the parties haven't. We had, and I believe that was because we indicated we were going to be filing a motion to amend it, phase 4. There's been no objection, so I think at a minimum, depending on what we do today, we need to start that if we are going to appoint a GAL. But
I do
my
have
client,
major,
hold on, sorry, I'm not done yet. Thank you, Ms. Gill. So we do have the motion today before you, Your Honor, to just simply amend that phase 4 schedule by a couple of nights. And that's what we have before you. I'm not 100% sure with everything that Ms. Gill filed, what was actually supposed to be in response. So what I did was took her first declaration that was 12 pages long and utilized that as a response. And so my client wants to proceed on the motion today.
Well, so is this a motion for adequate cause to modify?
It's just a motion to amend the schedule for phase 4. Since we're in phase 4, we had discussed it at the hearing in March, and they said if we want to amend, to file a motion.
The reason we did that is the way the plan is set up, phase 4 goes from me having him every weekend to me having him every other weekend. And with the connection and the relationship that we've built, I think it would do more damage than good to go to every other weekend, because he's used to seeing me every weekend and he's been asking for more time. So we went ahead to try and amend it in his best interest, so we don't lose that connection and the establishment of mother role.
my only concern, Your Honor, is that our original plan states that she cannot have overnights before having adequate housing. And 2 weeks ago, I was notified by the person that owns the home she was living in that she was squatting and was not a tenant, and she was evicted. So the last 2 weekends, she's been camping in her boyfriend's family's yard, which I do not think is adequate housing to have her overnight visits. It's very concerning. He needs stability and routine, and camping is not appropriate. I've submitted documentation of the text message I received on Facebook from the owner of the home. And I also talked to her about that. But I don't think it's appropriate to be camping every weekend when you're homeless and you don't have a home to take your son to for visits.
Your Honor, I'd like to say there is a civil matter between us and the landlord. I have had to call the sheriff multiple times, and every time they come out, they tell us this is a civil matter, that she has not served any eviction papers. She has not done any of the legal actions that she needs to do in order to have us leave. We are currently looking for a new apartment. I have scheduled meetings this week with 3 separate landlords. I am currently staying with family in an RV that's got a bed, it's got a shower, it's got a kitchen, it's got everything that he needs. It's not ideal, no, but it is adequate enough to continue my visits. It's only temporary. I am moving as fast as I can. We still have all legal rights to be in this home out on West Side Highway. I just have chosen, because of how hostile it has gotten between the landlord and us, to not put my son around that, because he doesn't need to see anything like that. And they have been very aggressive and hostile. So for his best interest, I've just moved the visits to family where he's safe, where the people here are approved through CPS as guardians, and they're mandatory reporters, so everything is safe for him. I'm doing all I can to get into an apartment as fast as I can. I've got all the money for it. I'm just waiting on the approval from the landlords.
Okay, and you have a valid license and insurance, yeah?
Yes, I have a CDL license right now, Your Honor.
All right.
So that's why we brought this, Your Honor. It's not that she's trying to make some crazy adjustment. It's just with her current plan right now, she gets every Wednesdays after school and every Friday overnight. And phase 4 has us going to every other weekend, Friday to Sunday. So it's the same amount of time, it's just allocated different. But the whole point is to transition Gage home, and going to her seeing him 3 times every week to 3 times every other week is going to be detrimental to that bond. And so we're just simply asking we had 2 proposals for a schedule, either adding on that Saturday every weekend for the first 3 weekends, or doing like a Friday to Sunday one weekend and then Friday to Saturday the other weekend, to kind of keep that bond up. And I think it's important to note, Your Honor, until Charity had me appointed and we started conversing in March, these issues hadn't been brought up. These alleged issues hadn't been brought up to the court. There was no motion. There was no request for a GAL. It's just when my client finally put her foot down and said, I want to move forward, it's time for my son to transition home. That's when the guardian started getting upset, which I get it. She's had him for 5.5 years. I get that there is a strong bond and everything, but it's gotten to the point where, due to the guardian's actions and her harassment and her hostility, my client had to file an anti-harassment order against her to get her to sort of calm down. And I understand, I really get it. It happens a lot when you have a child for that long. But at this point, we have to work on transitioning home. It's not appropriate for the guardian to be saying, you're my son, I'm your parent, this is not your mom.
I don't say that.
Excuse me, Miss Gill, if you could just wait. It's really like sad at this point. It's just, now we don't want to move forward. So we're simply asking to add those additional time and proceed on our motion today. Of course, we do have more to say than, just that. I just wanted to give the court a brief overview.
Okay, well, I guess here's the concern I have. This is a court order that was put in place back in 2020. I assume there was a guardian ad litem that may have had some impact on that proposal or that phase system. And I think absent a guardian ad litem input on, it seems to me we're on this, if she's complied with phase 3, then we move to phase 4. But if you want to change phase 4, I'd want to have a guardian ad litem look at it.
Okay, then we would ask we move into phase 4 today, and that, and if we want to change it, I'll speak with my client afterwards, and we'll talk about appointing a GAL. So we would ask that phase 4 starts immediately, which includes her Friday to Sunday starting this week, and then I'll discuss with her about amending phase 4 and appointment of a GAL. There's been nothing before the court that's been brought that says stop phase 4 or anything like that. We even have the guardian who wants my client to have every other week in the summer. So, Your Honor, we'd ask that phase 4 then starts immediately, and then I'll speak with her about amendments and appointment of a GAL to amend that.
Ms. Gill, and I did review your and it, I think there's some concerns raised. I don't.
And I did file a response to that, Your Honor. It just hasn't come across for you to be able to see it yet.
All right. So I guess here's where we're at. If she's completed the 6 months under phase 3, then we move to phase 4. And then if there needs to be some adjustment under phase 4 or some other issues, that can be brought back before the court, and we could take a look at a guardian if we need that.
Thank you, Your Honor. And just to note, my client is also 31 months sober this month, and she submitted all of her hair follicles in UA. And then just to be clear, Your Honor, since it is an every other weekend phase, can we have the order that her every other weekend starts this weekend?
Your Honor, my only concern is, so I am not opposed to having more time. My problem was for like 4+ months, she would not tell me where she was taking him overnight, which caused more and more problems because I wasn't allowed to even know where he was at. And I really do not think it's appropriate to go up to more overnights, sleeping in a camper in the middle of Kelso or sleeping in a field out of somebody's yard. if she's really trying to be responsible and get her son back, camping every weekend is not appropriate. And it's not stability for him. You know, he's not getting baths, he's not eating, he's not getting homework done.
That's not true.
Your Honor,
I'd
we're
like
gonna-
to-
Well, hold on, okay. If he's camping for every other weekend, that's certainly not gonna hurt a child of 7 years old.
Yeah,
Maybe-
the only reason we actually went
Ms.
camping.
Johnson,
Sorry.
just sit tight for a minute, okay? Okay, you've got an order in place. We're gonna follow the order unless I see a reason. And if we want to modify that, then I want to go ahead and invite him to weigh in on it and see. This was put together 4 years ago. I assume a lot of circumstances may have changed, which may change that order, but I think I need to see something that indicates that.
Thank you,
So,
Your Honor.
if it's been the 6 months, then we should switch to phase 4, which would start this weekend.
Thank you.
So it'll be every other weekend, Your Honor?
That's what it looks like in the order phase 4. I'm looking at the order it's in the.
Yes, Your Honor. It's every other weekend, Friday to Sunday.
And not Wednesdays. It's just every other weekend in our order.
Wednesdays was granted to me under the minutes in a previous
Let me
hearing.
hold. I'm looking at the order that's in front of me, which is the order we're working under, which talks about what phase 4 is.
Yes.
So phase
Okay.
4 is whatever it says, and I'm trying to locate it here. Phase 4 also includes the language for adequate cause if that's completed as it states. And it's basically every other weekend is what it indicates there.
I believe, Your Honor, what my client was referring to is after this. I'm not sure if it was I think it was Commissioner Nelson. There's a bench order that adds on every Wednesday. So there's a subsequent bench order from Commissioner Nelson that adds on the Wednesday visits.
You know where that is?
Yeah, I'm gonna if you give me one moment, find it right now. September 5th, 2023 bench order. And then let me open it up. I believe it looks like Commissioner Nelson, but it is a 2-page bench order and it's handwritten.
I have that. Let me just a second here. So that does, it looks like it adds Wednesdays 3 to 7, or it could be from 2:15 to 7. It's not, I mean, I have no idea what the intent of that was.
That was just me offering more time during phase 3 for her.
Was unfortunately not the intent. It was to offer additional time. There's been nothing stating no Wednesdays. So we would just ask we move forward with phase 4, continue the Wednesdays, and either party can bring it back if necessary.
All right, that sounds appropriate. I mean, again, I don't know what the basis for that change is. If it was an agreement, that's one thing. So that would stay in place, and then we go to the alternate weekend starting this weekend.
Can I
Thank you, Your
ask
Honor.
a question real quick?
Sure.
Could I, on the weekends that I don't have him, there is a protection order, so obviously I can't call Miss Gill herself, but I was wondering, could I have at least like some video visits maybe on Saturdays and Sundays through my if my boyfriend calls Carmela's phone?
I'm gonna leave it as is unless we have
Okay.
some, and if you want to modify it, we can certainly look at that and get a guardian appointed and determine if that's appropriate.
Okay.
In Your
Thank-
Honor, the only issue also I have is I have alleviated her pickup by allowing her to pick him up from school, but she's been changing my pickup location every weekend. We were meeting in Four Corners in Castle Rock at a general store in public. And then once she started camping, she wanted me to meet her in Longview, or she wanted me to drive to Kalama and meet her. And I would like to just have one place I could please pick up so I'm
Makes
not
sense.
messed with.
Is Four Corners was the prior place everybody was using?
Yeah.
It
Uh,
was.
Over a month.
Hold on,
No.
Your Honor. Hold on, Charity. Hold on. The order, Your Honor, says picking up like we see in parenting plans, picking up parent at residence or school. So that's what the transportation order says. And it's all the way back in that final residential plan. It hasn't been amended. We can certainly like work on it because I think having one solid place, and I've tried to work on this with Miss Gill, either one person's going to pick up or we're always going to have a halfway point. The problem is she wants my client to pick up and she wants a halfway point. So I believe we need to stick with what the orders say, absent an agreement. And the orders say picking up parent or guardian. And
There's a protection order now, though.
there's a carve out in the protection.
Yeah, there's an exception for us to have contact for pickups and drop-offs.
Okay, what is the protection order case number?
-08. I believe that's a 7.
That's not, wait a minute here.
Or maybe that's a Z.
I have it, Your Honor. It's 20.
Sorry.
Let me just look at that. I want to make sure we don't get either of you into any trouble. So let me look what that says. Looks like that's actually in the process of the hearing on that next week.
Temporary order is issued 3/14. It's been continued a few times.
Oh, I see. Okay. Let me see.
And I believe what happened is that the initial temporary order that was issued on the bench, Your Honor, didn't include the carve out. They went to the hearing and alleviated the carve out.
Direct contact between parties allowed for child pickup and drop off between the parties.
Yes.
So here's what I guess what we'll do.
So law enforcement has the most recent one from 4/8 that does not have the carve out.
They should have it because they extended the 325 order.
Yeah, they replaced it with the next one, so the one from 4/8 is the most recent.
Well, I mean, the order's still in place with the original terms. Well, I guess here's the problem. It looks like when that order was extended on April 8th, it did not include that carve out, even though I think the carve out would still be valid, but it still could result in a law enforcement interaction because it's not in the order that they're going to be looking at. And I don't know what changed that here. So
Before the exception was put in, Miss Gill and my boyfriend David Lee were doing contact to do exchange. That was working out really well. Both of them were civil to each other. I think that could be agreed upon to stay if that's the situation.
Yeah, I was meeting him at Castle Rock, and because we were 20 miles apart, our houses at the time.
okay. So I guess at this juncture, I'd be concerned about having direct contact because of the wording of that extension order. And that's not back on for hearing again until it looks like next Monday. So whatever happens next Monday, if there's an ongoing order that needs to have some language in there about this issue.
Okay.
Whether it's a permanent or temporary, but between now and then, I think going through the boyfriend probably makes sense to make those arrangements. And then Ms. Gill, if you and Ms. Jocelyn can discuss an agreement on the transfer a location or something. It seems to me having one place that everybody goes to all the time makes the most sense. That's not really a change in anything other than dealing with this new situation with the no contact order.
I've not
We've
had
been
very
doing
much
the
luck
manual.
dealing with Miss Jocelyn on that. I've asked for weeks now to have a concrete pickup, and she pretty much tells me, I'll check. You need to get a hold of them. You need to get a hold of them. And
Okay,
it's just changed on me.
Well, hold on. Where's everybody? Whereabouts do you live at, Ms. Gill?
I live in Longview, right by the lake.
Longview by the lake. I mean, Ms. Johnson, where are you living at?
Right now, because of the issues with the landlord out at West Side Highway, I am staying in Kelso on Elm Street.
Okay, so pending getting a resolution on this, why don't we have you do an exchange here locally instead of driving to Four Corners or something?
Yeah.
Maybe we use the McDonald's on Ocean Beach the one downtown, not the one out on Ocean Beach.
By the dollar store?
Correct, correct. And that's a reasonably good place because they're always open. They have cameras there, so it's a reasonably safe place.
I agree.
Okay.
And is that only for the exchange at the end of visits? Because my client picks up at school, or do you want the child to be picked up from school and brought there?
I think it's probably, if you pick it up from school, that makes sense because it's not any interaction between the parties, but for the return, let's do it at McDonald's in Longview, and that'll save everybody some drives.
Okay.
Perfect. Thank you.
Thank you, Your Honor.
So then on this case, we don't need to extend any orders because we're just waiting for, do you want to set another review on this or just let it go at this point and see if anything needs to be filed?
I think at this point, let it go, Your Honor, because they have avenues, like you stated before, to recite it on, but they also have provisions of what my client needs to do to ask for the child to come home. So I think at this point, just follow the orders and cite back on if needed.
Okay, so the only thing I would indicate, it might be useful to have something indicating that exchange place will be McDonald's, just so there's clarity there. If not, I mean, I don't think we have to have that, so.
Your
No,
Honor.
I think
Oh, go ahead.
Yes, ma'am.
ahead,
My
Ms.
only other concern of why I do want it reviewed is because them wanting to modify phase 4 doesn't take in consideration that Gage is going to be out for summer break. And I think that there should be a summer schedule in place to where it's not just weekends that she has him. She'd have more responsibility of him, which would be helping benefit her for a transition home. And that's why I was really hoping that there would be like a guardian ad litem, just because it's a very awful position for me to be put into to hold her accountable. And with the protection order, I can't even ask her for UAs anymore or anything like that. It's really like put a bind on what I am allowed to do or contact her about. But I do think that we need to have it revised for a summer schedule for him.
And I'm happy to work with Miss Gill. My client will do the week on, week off that she proposed, but we do have the phase 4 that states what my client needs to do and what is the basis for AC. So at this point, she can bring it forward. If Miss Gill still wants to do the week on, week off, I'll talk to my client afterwards and we can reach an agreement and send a stipulation into the court. I don't think there's a need to review this.
Yeah,
nothing
because
in
the order
plan.
doesn't state a summer
Hold
schedule.
on, Charity, hold on. We have the orders in place and each side knows what they need to do if they need to modify it. This was a plan to set forward. I will talk with my client after this hearing about week on, week off. And then I can send over stipulation to Miss Gill to sign to convert it for summertime for that. And we can agree on a pickup and drop off time and day.
I was
But
only
if
willing to agree if a guardian ad litem could investigate wherever he would be staying.
Okay,
Because
well,
going a week
let me
on-
stop, let me stop you both. So I've got phase 4, which talks about 18 months for something.
For me to be clean that long, and I've been clean for 31 months.
Ma'am, I can read. Okay. So
Sorry, just
I don't know when that runs from, if that runs from the phase 4 starting or if that starts from some other point. So that may be an issue, but in any event, the phase 4 is a visitation schedule. It doesn't say a week on, week off. So if you guys agree to something else, that's fine. If you want to bring it back in, we have a guardian appointed to look at a modification of that. That's fine too. But right now it's phase 4.
Thank you, Your Honor. And
Okay.
just for housekeeping, as I was appointed, does the court want, since we're done, does the court want to relieve me today or how does the court want to handle that moving forward?
Absent there being any, I guess my thought would be is, why don't you talk with your client, see if there's any need to do any adjustments of any kind, because it'd make more sense to just deal with that than go through a reappointment process if we need to.
Okay. Thank you, Your Honor. Appreciate it.
Okay, if there's no need to, if you want us to send in a final order relieving you and with the billing, we
Okay.
can take care of that.
Okay. Thank you, Your Honor.
All right.
thank you, Your Honor.
All right. Good luck.
Thank you.
That matter's ready, Judge. Carly Bliss on behalf of the minor, Kayla Randall, on this matter.
Kurt Anagnosto on behalf of the mother.
And I see Ms. Farr, who was just reappointed. Looks like, have you been able to talk to anybody at this point, ma'am?
No, Your Honor, I have sent out emails this morning to request interviews. We did have interviews set up a week ago or so, and I had moved that week and I didn't have internet the day that we had the interviews set up, so I've asked to reschedule them.
All right, and it looks like the discussion today was to be about prospect of reunification counseling, is that correct?
It's to review the reunification counseling. It's been
Okay.
ordered. On behalf of my client, she is in the process of getting that set up. She had an appointment and got ill and couldn't make it. But it's my understanding she has an appointment to begin the reunification counseling process.
Do you know how far out that is?
Kayla, I think it's next week. Is that right?
It's tomorrow.
It's tomorrow.
Okay.
I mean, Dan,
So Ms. Farr, from your standpoint, how much time do you think we need for this review?
Well, ideally, I'd like to set it to April 11th, but if the attorneys believe that's too far out, then I could do my best to rush to get my report in before 3/28.
That gives us about a month's worth of the reunification work. That's probably pretty good. Ms. Bliss, that okay by you?
I would agree, Your Honor. I think knowing that the appointment is for tomorrow, I think it makes sense to set this out a week or an additional period of time to allow some information from the reunification counselor as well, because I know that that's going to be a big help.
Mr. Anagnostou, April 11th work for you?
it does. I was hoping we could get in sooner just to see where we're at, but my
That-
client wants to
That
move.
gives us enough time to get something under our belts and get some good information.
All right.
All right, April 11th
Your Honor,
then
attorney
at
for
10:30.
petitioners
you,
and
Judge.
emergency temporary guardians.
Kurt Anagnostou on behalf of the father, Jack Carnahan.
Donald Esau on behalf of the mother, Katrina Vorse.
In council, we are on today. It indicates to approve petition to modify. We also have a termination hearing set the 21st, it looks like.
Yes, Your Honor. We filed a petition for the full guardianship and are asking the court today to approve that petition. There's been a little bit of confusion because Judge Hahn was very clear in our last hearing that at this hearing today, we were to address the issue of paternity for Mr. Carnahan and discuss appointing an attorney, but that paternity needed to be established and clear before we could talk about visitation for him. I see that an order appointing an attorney has been entered. There was also another objection and petition to terminate that was filed 2 days ago.
Yes.
There hasn't been anything filed to establish paternity beyond what had already existed, which Judge Hahn had told us in the last hearing was not sufficient. We also discussed in our last hearing visitation with Katrina Vorse. I do not believe that has happened yet. Tina Day has been appointed the guardian ad litem in this case, and we are waiting on her report as well. There shouldn't be anything before the court preventing the entry of the full guardianship, however, but if Tina Day needs more time for her report, I think we should hear from her.
Ms. Day?
Yes, Your Honor.
That's first where we are in that regard.
So I completed the court visitor report previously and then was appointed as the guardian ad litem due to the conflicts within this case. I would at this point object to entering the full guardianship until I can finish my full investigation as the guardian ad litem, because that role is very different than the court visitor. But Jessica should stay with the petitioners in the interim for that. We still have the issue of paternity where father is concerned. That has been kind of an ongoing conflict, because father was not on the birth certificate at the filing, and then the parents amended the birth certificate and appointed somebody to be the father, and that has been provided to the court. That's not been adjudicated. So that hasn't gone through the process with Office of Support Enforcement or through a hearing to establish him as the child's father. He has previously denied being the child's father, and then as a result of this guardianship came forward in that. And I'm sure Mr. Anagnostou can provide more information. My main concern at this point is it's very difficult for me to assess what is happening as far as the visitation, because visitation is not happening. It's been ordered multiple times and it simply has not happened. This child has not seen her mother in several months. And all the efforts to get that moving forward have been thwarted one way or another. Part of that is mother has refused or failed to provide a UA. I have reached out to her probation officer to see if we could maybe go that route. I've suggested that mother enter into substance abuse treatment and we can receive those UAs, which would provide proof of her abstinence. But I don't have any information that any of those things has happened. So I'm very concerned about what's happening emotionally with this child because the interruption of her relationship with her mother. And then my second concern being some of the information provided in the response from the petitioners has raised some additional concerns. And I don't know if the court wants to go into that or not right now or wait for my report.
Well, let's wait on that for the moment. Let me ask a couple of questions. First of all, Mr. Anagnostou, as far as the paternity matter goes, where do we stand?
Well, Your Honor, I was only recently appointed, and I reached out to my client. I haven't had an opportunity to talk with him before today's hearing, and was going to ask for additional time. I've looked through the pleadings, and there's a lot. This case has been going on since late last year. Anyway, I was only recently appointed and have not had an opportunity to talk to my client. I would ask that the court not grant basically the full guardianship until I've had an opportunity to get involved in the case and get up to speed with regards to the paternity issue.
All right, Mr. Carnahan, can you hear me? I see his name there.
So do I.
All right, Mr. Carnahan, I'm going to assume you can hear me. You need to contact Mr. Anagnostou's office today, get in to see him right away. All right, and Mr. Esau?
Yes, Your Honor. Regarding the visitation and the UAs of my client, she does not have the funds available to produce a UA. That's been going on for several weeks now. We do have a date of March 14th for her to get in and get a substance abuse assessment and to get into recommended treatment after that. I know that's another week out, but that would give her the opportunity to get UAs if she does get into inpatient or outpatient treatment, whichever the assessment is. At this point, I think
I'm sorry, what's the date of that assessment scheduled for?
March 14th.
Okay.
So a week from today.
All right.
Yeah.
Ms. Morris, you understand how important it is that you make and keep that appointment? Okay.
Yeah. So we would oppose the entry of a full guardianship. We're not really opposed to an emergency guardianship being established because I think we're still on the immediate order was the last order entered. But it would seem appropriate at this point to at least enter the emergency guardianship, and that gives us another 60 days before we proceed with any petition for full guardianship.
Yeah, Ms. Day, from your standpoint, how far out do you think we need to be for you to do your job?
I probably need 2 or 3 weeks to finish writing my report. So if we could go out 30 days, I should be able to have my report done and circulated to all the parties between now and then.
And is that agreeable to everyone? Then let's go out about, let's say that April 4th date.
Sure.
Your Honor, I am out of town on April 4th. I apologize.
The 11th?
The 11th will work.
That works for
for me, Your Honor.
Yeah, that works for me.
All right. The 11th then, Mr. Carnahan, get in to see your attorney. Ms. Morris, make sure you make that appointment.
Tina Day, guardian ad litem here for the Wilson matter.
Okay, I'm not showing anybody in the waiting room.
Rebecca Beck, petitioner.
Yeah, I don't show anyone there, so hopefully they're in now. All right, Ms. Beck.
Yes, Your Honor.
It looks like we're still trying to make service on the mother. Is that right?
No, she's been served since December.
We're trying to affect
And
service
she was
on the
here
father.
last week.
Oh, okay. I'm sorry, on the father.
And he was served last Thursday, Your Honor.
Okay, it looks like we don't have proof of that yet. So
It was turned in Friday morning.
Okay. Let me look here. Okay, I see that here. All right. All right, do we have anybody else appearing in this matter?
Your Honor, this is Casey Looney on behalf of the state. We have not yet put in a notice of appearance, but when I was reviewing this case, I did come up with some potential issues I wanted to bring to the court's attention if I could be allowed to speak.
Please.
Your Honor, the main concern that I'm seeing is that there may be need for a UCC JEA conference on this case. I didn't see any evidence that the child had lived in Washington with a parent. The child has not yet been in Washington for 6 months. It also looks like there may be issues with jurisdiction over the father and some potential issues with legal status of parentage. That was all established in Oregon. So it appears that there may be stronger ties for Oregon to hear this case than there are for Washington.
Your
I
Honor,
can address
Miss
that.
Raleigh put her
Okay,
in.
hang on just a moment. Hang on just a moment. All right, who else did we have? Other than Miss Beck? I thought someone else spoke up. All right,
I don't see the mother or the father at this point.
Yeah, go ahead, Miss Beck.
Thank you.
Your-
Ms. Looney is accurate that the mother did raise the concerns about jurisdiction. And I think there's no question that the child had resided in Oregon for the majority of her life until she was placed with the Becks voluntarily by mother to avoid DSHS in Oregon taking custody and placing the child in foster care. That was done by agreement, and the court here has made an emergency decision, and that has continued until last week when that information was brought to light.
Okay,
I would agree.
that occurred in October, correct?
That is correct. So jurisdiction, I think there could be an argument there, but it has been, at least on an emergency basis, established. And I think that it's appropriate that it stays here at this point. I am working with social services in Oregon trying to obtain some of the information on parentage because the father name has been determined not to be the biological father in Oregon, but there's been a lack of follow through on the paperwork by the parents to disestablish him. And so we're kind of in a little bit of a legal limbo there. But we are in that process. And I certainly think that moving forward, we should be sensitive to that issue if the parents were going to participate or if a new father is identified. At this point, there has not been a new father identified.
And counsel, what actions have been filed in Oregon other than a parentage action, if any? Was there a pending dependency of some kind?
Your Honor, I'm not aware of what's been filed in Oregon. All I'm aware of is what's been filed here in Washington. And I did see that there has been CPS involvement, but my understanding is there's not an open dependency at this time in Oregon.
All right, Ms. Beck, to your knowledge, what kind of cases, if any, are there in Oregon?
I know CPS has been involved, but there's no open cases in Oregon to my knowledge.
Oregon declined to file once the decision was made to place the child with the Becks. If the child is returned, they would file a dependency based on the child being positive for fentanyl and the other allegations that had occurred and the prior charge of child neglect from the year prior.
Excuse me, Your Honor, that fentanyl test was 95 days after the fact, and I hadn't seen her for
who is speaking?
I'm sorry, I'm Vanessa Rowley. I'm her mother.
All right, so are you objecting to this guardianship at this point or not?
I am, because I am willing and wanting to take care of my child, and I also have tried to mail in a motion to dismiss based on jurisdiction because my child is not a resident of Washington and never has been.
Okay. I'm going to maintain the emergency guardianship at this time. Ma'am, I suggest you file a request to have an attorney appointed to represent you, and we'll take a look at that. And it sounds like we need to be out about 30 days. So I'll extend the emergency guardianship through.
Your Honor, but if there's a jurisdiction issue, meaning that it's not even supposed to be, yes?
Ma'am, everybody's entitled to be heard on that issue. I understand there may be an issue. If there is, there has to be a conference with the judge who's handling the matters in Oregon. And that's going to take some time. So I'm going to continue the matter till April 11 at 10:30. As I said, I strongly urge you to file a request to have an attorney appointed to represent you. You understand that?
What, excuse me, I understand what you're saying, but my question is that I have the right to oppose the objection or object to the jurisdiction, and I have the right to, and I also don't, if I get an attorney via Washington, then that says basically that I agree to let it be heard in Washington, and that takes away the jurisdiction, which is not what I can do.
No, it doesn't, ma'am. So as I say, I'd strongly urge you to put in a request to have an attorney appoint you in this matter. I'll continue the emergency guardianship to April 11.
But if the jurisdiction isn't in your jurisdiction, this would.
Okay, ma'am, as I said, that has to be determined by a judge. It's going to require what's called a UCC JEA conference between the judge in Washington and a judge in Oregon, wherever that proceeding may be, if there is one in Oregon. So there's still a lot to be determined and a lot to be done before we can make that determination. Right now, there is emergency jurisdiction in this state, which the state has already asserted, and I'm going to maintain that through that April 11 hearing.
Your Honor, I did have a question.
Yes, ma'am.
Regarding the protection order. We go back to court next week regarding that. Is there any way that we can get that protection order adjoined to this case?
I don't know anything about a protection order. You know, I don't have that case in front of me. You'll have to address that next week.
Okay. All right. Thank you, Your Honor.
All right. That will be all. And so I need to.
Thank you.
Rick Haycock.
And I see Ms. Holm.
Hi, yeah.
We have Alicia Marshall Renner and James Lato.
Okay, so first of all, I mean, Ms. Holm, are you objecting to the emergency guardianship or not?
I'm not sure. I mean, I want to give them guardianship because they are helping me care for them. I think I would like to do that. I guess I disagree with a lot of the paperwork that I was reading, like having a restraining order and that I don't think are necessary.
Okay, but you are in agreement with the emergency guardianship at this point, is that correct?
Yes.
Okay. And father?
Yeah, if they're thriving right now, I didn't know the situation. I'm a little behind on their situation, but yes, if he's good with them, I want what's best for the kids for now. But I would like to be able to give my children to them on a regular basis, if that's all right. For now, until everything gets stable, for me and for the kids.
All right, I will extend the emergency guardianship for 60 days. That puts us to looks like May 2 at 10:30. And I'll sign an order to that effect. Folks, you need to look at whether or not you're going to file for a full guardianship. And Mr. Staniker or Ms. Holm, you need to decide if you're going to put in a request for an appointed attorney.
It's Haycock, sir.
Haycock, I'm sorry, I'm just looking at the last name there. Okay, so I'll sign those orders today.
Okay. And then do we go into the courthouse to get a court appointed attorney?
Yes, ma'am.
Okay.
All right, that'll be all. Thank you.
Thank you.
What about,
Thank you.
Communication with the letter?
I'm sorry?
What about communication, my communication with the children? I'd like to call them and can we establish that? We didn't really establish that.
All right, folks, do you have any objection to phone calls with father?
We're okay with that, Your Honor. We just, the protection order thing was mainly they couldn't be taken out of school by anybody other than us at the moment. So we're okay with like phone calls and communication. It was mainly tried to put in place for protection of the children.
Okay, so sir, you understand they're setting the rules at this point on that kind of thing.
Yes, sir. Yeah.
Okay.
I just like to say they're doing great. I haven't got to talk to them or anything. I just caught wind of this, so I've been behind.
All right. May the 2nd at 10:30.
Okay, thank you, Your Honor.
Thank you.
Thank you.